You heard Mr. Chachuchikata on his feet for about an hour trying to establish the necessity for which they should be granted leave to inspect these documents. And you heard counsels on the side of the first and second respondents argue that no necessity has been demonstrated because all of those documents are already in the custody of the petitioner. And the petitioner has not demonstrated before the court that there's anything wrong with the copies that he has, and therefore asking to inspect the originals, because you have the documents already. Indeed, some of those documents were attached by the petitioner himself to his petition, some of the witnesses as well to their witness statements. And so the principle, the legal principle of necessity for fair disposal of the matter has not been demonstrated. And there has been no argument even made about a reduction in the cost of litigation. We also noticed, principally, that as the case moves on, and particularly with this application, the petitioner is now seeking to invite the court to breach a time-tested rule in litigation that he who alleges must prove. You come to court with your own case and your burden of proof is on you. It is when you have satisfied what we call a case, you have made a case in law, that the burden of proof now shifts onto the respondent or the defendant to respond. Indeed, if by the time you are done, and for those of you who are court correspondents, you will know, if by the time you are done submitting what you think is a case, the legal threshold of making a case under the law has not been made, the respondents or the defendants have the opportunity to move a motion for no case because you have not made a case. So it is when you have moved a case and satisfied the legal threshold that the burden of proof shifts. We are observing that this is an attempt to shift the burden through the back door. Now, the court, as you observed, rose to consider the various arguments and came with a ruling. Before then, plaintiff had made an argument that if you have nothing to hide, why don't you produce the documents? Those documents are even on the internet. They have been published already. They are within the custody of the petitioner. So don't be swayed by this propaganda line that if you have nothing to hide, why are you not producing the documents? The documents have been made available. They are already in the custody of the petitioner. They are in the custody of all other political parties or candidates who took part in this election. They are in the custody of the second respondent. And they have not demonstrated any necessity for it. In the end, the court ruled, and I just want to quote what the court said through the respected Chief Justice. It said, the applicant has not demonstrated the necessity that must be met. And that indeed, on record, they have admitted that they have the documents. No proper case has been made for this application, which we have spent a number of hours on today.